My name is Sean Young. I'm the co-founding attorney here at Watson & Young. I have my co-founder here.
I'm Zara Watson Young.
And today we're going to be going over common questions that we get in the trademark space. A lot of clients come to us and they have these questions, so we thought it was a good idea for us to just get together and really discuss some of the prevalent issues that we face as trademark attorneys. A little bit about us: we started the firm back in 2017. At that time, it was Zara Watson Law. I was always behind the scenes, but we decided to join forces officially full-time, and it's really the culmination of a dream of ours that we shared back in college. We've known each other for that long. Newsflash, this is also my amazing, smart, beautiful, talented wife. We're a husband and wife team. And really, we enjoy and love what we do because each and every day we get up and we get to serve our clients and help protect their business, stop them from losing their business because imitators are coming in, copycats are coming in and stealing their intellectual property. And so our firm is really designed to help small, medium, large businesses protect their intellectual properties, because we know that businesses' intellectual property is what the source of revenue, their ideas, their concepts, their proprietary information. These are all important to your business. It's how you make money. And so having the right intellectual property team behind you is critical at any phase of your business. So we're going to go through a few questions. We have our moderator, Isabel, in the background. So Isabel, why don't you give us the first question?
What exactly is a trademark and why is it important for my brand?
So a trademark it falls under intellectual property. Specifically, it falls under what's called the Lanham Act, right? And really what it is trademarks protects your name, it protects your slogan, and it protects your logo. So really what trademarks does is it protects your reputation and your goodwill in the marketplace. Because anytime you have a business, you need to name that business, and that business then that name becomes your reputation. So consumers will identify your business by that name. Now imagine, let's say you're a skincare line and someone comes along and is taking the same name. Now they're driving traffic to their website, they're taking your customers from social media. They're basically imposters and they're taking your business. And it also helps guard and protect your reputation, right? Because clients rely on that name. That's how they know that this is the product that I want to buy. And now if someone else is taking your name, they're confused, right? And they can't trust where this product is coming from anymore. So trademarks is the legal tool to protect your legacy, protect your business, and protect your brand.
Sean said it perfectly. It really protects you just across the board. It's really the foundation for everything in your business. When you have a trademark, you have the exclusive rights to go after anyone who might be copying you, right? You have the exclusive rights to leverage your trademark if you want to go into a licensing deal, if you want to work with partners and do collaborations. All of that comes down to owning your intellectual property. So Sean said it perfectly, but I wanted to add that additional information.
Absolutely.
When is the right time to trademark my brand? Should I wait until my business grows?
You want to start the trademark process as soon as possible. The earlier you start, the better, right? If you have to even pivot, for example, let's say the name that you've chosen and that you love is unfortunately unavailable, you will have the opportunity, if you start early on, to make any changes that you need to, right? Of course, we don't want that to happen. However, if you start the process early, you just have, going back to leverage, you have so much leverage to make any changes, any pivots. So the sooner you can start, the better.
Yeah, Zara said it perfectly. You don't want to wait until it's too late. You don't want to wait until you've invested your money, your energy and equity in building a brand, and then come to find out you didn't trademark, and now you have to start back to ground zero, right? Because you've received what's called a cease and desist. And someone's basically telling you, hey, either you change your name because we've had it before you, or we're gonna sue you. And so these are common stories that we hear every single day. And that's why it's so important to have a trademark strategy from the outset. It's critical. People say, I didn't know I needed trademarks, or trademarks are expensive. It really boils down to, what do you value? Do you value your time, your energy, and your money? Then you're going to make sure that you have the right comprehensive legal strategy from the outset so you can avoid these pain points, because it is painful having to tell our clients, hey, you don't have a case here. You have to rebrand, and I wish it came to us earlier. Now, we do our best to mitigate the damage. For instance, sometimes we'll slow roll the process of a cease and desist, and we'll be able to buy our clients time so that they can create an off-ramp and start the rebranding process and recoup some of the money. These are all strategies that we can employ. However, it's so critical. Had you come to us from the outset, it would have been so much better. And so that's why it's important to have that from the outset.
I agree 100%.
What's the difference between a trademark, copyright, and patent?
Trademark law protects any of your branding. So any of your brand assets, like your logo, your slogan, your business name, any catchphrases that you use, so anything dealing with the actual branding of your logo. If you have a submark, a lot of designers will send like a primary logo or a secondary logo and submarks and different icons. All of that can be protected under trademark law. Copyright law protects, basically, I like to say, your content. So any of your, we like to say, tangible works. So for example, if you are an author, the actual content of your book, that could be copyrighted. If you're a photographer, the images that you've taken, that could be protected under copyright. On your website, all the content on your website, that can be protected under copyright law. So I always say copyright equals content and trademark equals your branding. And then finally, we have patent law. So patent protects any of your inventions. So anything that is a novel invention. So we like to use, the example of a television, right? When that was first invented, that has been patented. My gosh, the Apple, the Apple phone, Apple Music, actually all of those things have received patent protection.
Yeah, I think the perfect example that I would use, because Zara said everything perfectly, the perfect example I would use is like Nike. Nike is a great example of the intersectionality of intellectual property, right? What do I mean by that? So you have Nike the brand. We all know Nike the brand, the check mark, it's iconic, and they have it on their shoes. Now let's say Nike develops a new shoe, right? Now the shoe, with that technology, if it's new and novel, like Zara had said, it would be protected under patent law, right? Because it's a new technology. But also the design of the shoe would be copyrighted, because that design, you're putting pen to paper, you're designing, you're drawing it out, you're doing the dimensions, that would also fall under copyright law. And then we have the trademark, which you're slapping on to the actual shoe. So a lot of these concepts and ideas, we understand why it's confusing, because there's a lot of intersectionality there, but those are the three differences between your intellectual property when it comes to trademark, copyright, and patent law. And there's a fourth, actually. It's called trade secrets, but we'll cover that in another session.
Can I trademark a logo, brand name, or product name, and can I do it all at once?
Absolutely, you can. You can do all three. You can trademark your logo, you can trademark your brand name, you can trademark your word mark, you can even trademark slogans. However, it's very important that you understand that these are separate. These would be separate trademark applications. Each would have a unique trademark applications because they are distinct, and the USPTO treats them as distinct. And also, when you come up with a trademark strategy, you need to come up with a trademark strategy for each of these elements of your brand, because you might not have a competitor in the space for, let's say, your word mark. That might be very unique, but your logo, there's an argument that can be made that's confusingly similar to another logo out there. So each brand element, you need to do a comprehensive legal strategy, and they would all fall under a different trademark application.
Yeah.
How long does a trademark process take from start to finish?
So the trademark process can vary. It is a lengthy process. So you're looking at anywhere between 12 months to 18 months or potentially longer. And initially, the actual review process takes 8 months. So sometimes it's shorter, but ever since COVID, still the USPTO has been backlogged. So you're looking at anywhere between, like I said, 12 months to 18 months. So within that first 8 months, you're basically waiting to hear back from the USPTO. Once they review your application, they will either approve your application and it'll proceed to next phases, or they may issue what's called an office action, and there are two types. One of them is called a non-substantive office action, and the other is called a substantive office action. And basically, these are both notices that the government is sending out because either there's an issue that they want you to correct or update, or there is a more serious issue where the government is saying that, maybe there's going to be likelihood of confusion with another either registered trademark or someone else who just filed an application, and they're saying that there's confusion. So there are other issues, but those are the most common ones. And then from there, you have an opportunity to respond to the issue, correct it, or submit we call it a legal brief, to make arguments to show why your application should register. And then from there, assuming everything is good to go, your application will move on to the next phase of the process, which typically takes 30 to 60 days, and it's called publication. So publication is where the government is letting the public know that you are interested in registering this trademark, and they will give the public an opportunity to basically oppose your application, to say, hey, I've been using this mark, or it's going to cause, confusion in the marketplace, it's going to prejudice me as a business owner, and I want to oppose this application. So the government will give you 30 days to do so, and assuming there's no opposition, your application will basically be reviewed one final time, and then it'll be registered. So like I mentioned earlier, all in all, you're looking at between 12 to 18 months.
Yeah, and that's provided there are no issues. I think Zara mentioned the opposition period. Listen, there are Fortune 500 companies out there, and all they do is monitor the Trademark Gazette. And essentially that's the publication where you look to see what's about to register, and it gives you that 30-day window to oppose the mark. We've had cases like that in the past where our clients have come to us and they say, I thought everything was okay, but now I got this letter from, let's say, we were talking about Nike earlier, Nike, and they're basically coming after me. What do I do? And so that's why it's very key from the outset to have a comprehensive trademark strategy before you file, because we can avoid these issues in the past, and we can also try and get your application through a lot smoother. And then also, as you are waiting this 12 to 18 month process, you do have some trademark protection. You have a pending application, and essentially it's first come, first serve, so any trademark applications that come after you will be flagged pending your review. So that's why it's so important to get your trademark application in as soon as possible, because it will prevent anyone coming in and using your mark from after you. So you gotta race to the finish line. You gotta make sure that that you get your trademark application in sooner rather than later.
What's involved in a trademark search, and can I do it myself?
The answer is we don't recommend it. Yes, you can do an initial search. However, if you do not have the experience and the expertise, like a trademark attorney, you're not going to know what you're looking for, right? You're not going to know what you're not looking for. So it's really, really important. We cannot stress it enough how important it is to hire an expert, an experienced trademark attorney to do a proper search for you, because that could really cost you. You can, miss, maybe a misspelled or different spelling of the variation of your trademark, or not, do a proper search for a logo that you might have. And remember, the process takes at least 8 months for you to hear back from the attorney, right? So you're really wasting a lot of time, and you're risking your business by not hiring a lawyer to do it for you properly.
Yeah.
If you make a mistake, you're going to have to basically potentially hire a lawyer to correct that mistake, or even start over, right? So it could really cost you. The search process, it's very intricate. You're looking at the United States Patent and Trademark Office, their database of registered trademark applications, pending applications, abandoned applications. You want to make sure that there are no marks that have been abandoned, and those abandoned applications can actually revive their application, right? They have a time period to do that.
That happens too.
You want to make sure that you are not missing any of those things, as well as doing a search on the internet, right, and social media, because there are businesses who may not even know about trademarking, and they don't have a trademark application. However, when they Google themselves, they'll look themselves up and say, oh my gosh, so-and-so has been using this mark, and I've been in business for 5 years, 10 years, 15 years. So you want to avoid all those issues and you want to make sure that you're doing a very holistic search. And truly, only an experienced attorney can do that. So you want to make sure that you're not prejudicing yourself now and also in the future. So comprehensive search is critical.
It really is. And can you do it yourself? Like Zara said, sure. Can you look at an X-ray yourself and kind of assess, like, oh, this is an X-ray. Oh, I see my rib cage. I see a bone here. I see a bone here. But you're not going to know really what to look for unless you're a doctor. So it's the same concept. Unless you know what you know what to look for, you know the ins and outs, you know the loopholes, you have the experience. Like Zara just mentioned, the revival of an application. Yeah, you could have a canceled application. You think, oh, this is great. Look, this guy has the same mark as me, but it's canceled. but you go and apply, lo and behold, this person revives the application, and now your application is denied and rejected because you just didn't know that. You don't know what you don't know, and you hire experts that do know so that you can focus on what you're doing, which is building your business and that particular service or the goods that you're selling, and scale your business while qualified, competent legal counsel can handle the rest.
And look, we understand bootstrapping, right? We started this business in 2017 and really built it from the ground up. And I can tell you wholeheartedly that the search process is not something that you want to skimp on or go a cheaper route, because again, it will really cost you long term. If you wholeheartedly believe in your business and what you're building and really want to make an impact, this is not something that you joke around with, right? You want to make sure that you're doing the search properly from the start.
Yeah, absolutely.
If I have an LLC, isn't my brand already protected?
I just feel I've seen so many businesses get burned, so it's like I love what I do and I want to make sure that you're protected. So no, having an LLC is not going to protect you.
That's right.
It's wonderful that you have an LLC, and an LLC stands for a limited liability company, and it basically does just that, right? It's protecting you from liability. So you have to think about it from the perspective, okay, oh wait, I have liability protection, however, I don't own my brand. That is where trademarking comes in. So trademarks helps you actually own and go after other people who are copying you, okay? And what I mean by own is you literally own the rights to the business. So if you want to sell a business, you'll have the opportunity.
Exclusive rights, correct. Yeah.
Yes, if you want to sell the business, you'll have the right to do that. If you want to license or enter into partnerships, you own the intellectual property, so you'll be able to do that. And also, like Sean just mentioned, it gives you the exclusive rights to go after anyone else who's copying you. So if someone else is infringing on your trademark, let's say you go on Instagram, you're scrolling and someone else is using the same trademark to sell a similar product or service, you have the rights to go after them and have them take things down. And that could mean so many things, right? What are they taking down? Is it just a website? Do they have a physical brick and mortar that they have to now change, the signage, product packaging? So that means so much. And then you can also even go after them for maybe they're making money, they're profiting off of this by using your name. So you can actually recoup a certain amount of monetary damages because you own the trademark. So having an LLC is not enough.
Yeah, it's called disgorgement of profits, and then you can only do that with a valid trademark. When you form an LLC, for the people in the back, you're going to the state database to file that LLC. Trademark protection, the USPTO gives you protection in all 50 states, right? So that's the only way to get that broad federal comprehensive protection. Not going to the state and filling out the name, but I get it all the time. But my LLC, I named my LLC and it was the only one that came up on the state database. Let's say you filed in Delaware. It's the only one in Delaware, yeah, but trademarks protects you federally. So if someone has the same name in Michigan, but they went ahead and they trademarked it, right? And so they have all 50 states. The fact that you have an LLC, which is only protecting liability, and you just so happen to have it available on your local state database, it doesn't mean that you have broad federal protection. And I think that's an important distinction, because there's another follow-up question that we get.
What happens if someone is already using my brand name or something similar?
So if someone's using your brand name or something similar, you need to call us. I mean, that's what needs to happen, or call a trademark attorney, because we want to make sure, you don't just go out and say, hey, stop, right? We want to do some due diligence. We want to do a background check on this company. We want to find out, one, are they operating in the same space as you? They may have the same name, but they may operate in a different space. Newsflash, a corporation can have the same name and coexist. That's why you have companies like Delta Airlines and Delta Faucets, right? Same name, two completely different industries. So we want to assess what trade channels are they in. We want to assess, whether or not they have a trademark. We want to assess, okay, if they have a trademark, when were they in business? We want to clearly line up the differentiating factors and the unique and similar factors. And then once we finally do that, we want to put together a strategy. Are we going to send them a cease and desist? Are we going to coexist? So there are a number of things that can occur, and you see it all the time. Sometimes two big brands, they decide to end up either fighting it out, or maybe they coexist, or maybe they create some kind of licensing agreement. But the key is to do that due diligence. Don't just go out and DM them and tell them to stop. You need to come up with a comprehensive strategy, because if you don't, it could cost you your business. So It's important to know who these people are and do the due diligence required.
Yeah, and to add to that, I would also say a few initial things that you can do is number one, just make sure that you are taking screenshots of the actual infringement. So if someone is copying your website copy, or maybe they're posting on social media, just take screenshots of that and save that information, because oftentimes when you initiate, they will remove everything. So you want to actually at least have some evidence of the infringement. So that would be create a folder, a zip file, and just send it to the attorney. I do not recommend, like Sean said, sending a cease and desist on your own, because it can really hurt you. And the reason is because you may be sending a cease and desist to someone who actually has what's called priority rights over you, right? So you could be letting the person know that actually they were using it before you. So you want to be careful in terms of how you're sending a cease and desist. So the only thing that I would recommend doing is just gathering that proof, that evidence that you've discovered, and just saving it on file. Any correspondence, maybe you reached out already, saving those DMs, maybe you received an email or already initiated an email. So saving all and any correspondence from the individuals, and then the proof, and then you reach out to an attorney.
Yeah, I think another thing to save too is if your customers and your clients are coming to you and saying, hey, this person is using your name, I want you to be aware, because the standard is consumer confusion, right? Because we want to say, hey, you are taking clients you're from us, or you're confusing our clients, and so that is critical evidence, so always save that as well.